This is not a clown show.
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
You, Mr. Hurst. I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this.
Talking.
Plaintiff admitted that too.
All right, everyone. This one's a wild ride. We've got a sovereign citizen in court going full conspiracy mode, claiming he's a living soul and rattling off all the usual nonsense we've come to expect. But the real highlight? The judge actually laughs in his face. Here's the backstory. This guy racked up a bunch of credit card debt and now owes the plaintiff a serious chunk of money. But instead of owning up, he pretends he has no idea what's going on, denying everything and acting completely clueless. It's one of those moments where you have to wonder if he actually believes the stuff he's saying. Let me know in the comments, do you think he's for real or just trying to game the system? Either way, get ready, because this judge does not hold back. Let's dive in and watch him absolutely shut this guy down in front of the whole courtroom.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right, Mr.
So
Hurst.
we attempted to do discovery anyway. So.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I open written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept it.
I'm not even sure. I do not have any understanding of this is my debt or not. They just coming with these allegations. I'm trying to see and verify if it is. When they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already,
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. She cut me off.
You, Mr. Hurst. I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this.
The judge might not think this is a circus, but the second this sovereign citizen joined the Zoom call, it turned into a full-blown clown show. I mean, seriously, this guy can barely put a sentence together. It's like he skipped every English class just to study the fine art of legal nonsense. Did you catch how he said refuse at the beginning? That cracked me up. And let's not forget, if he had just accepted the mail from the prosecutor, he might actually know what he's being charged with. But nope, he's out here freestyling the classic sovereign citizen script like that's going to magically make the law disappear. It blows my mind how they cling to this whole, I don't recognize your authority routine, like the court is just going to go, oh, our bad, carry on then. That's not how any of this works. Now, I'm not trying to be too harsh here, but you've got to wonder what's going on in someone's head to think this strategy is ever going to work. Let me know in the comments if you think these folks actually believe what they're saying or if it's all just an act. Anyway, let's jump back in and watch this judge straight up laugh in this guy's face. It's priceless.
You
Oh
will
my
speak
goodness.
one at a time.
I can't finish my
You
statement.
will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr.
Yes, sir.
Hurst?
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute
I don't
you.
even understand what's going on.
I'm muting Mr. Hurst, and I will let Ms. Strickard say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickard, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refused the packet, because I don't know if they're trying to contract with me or not. I didn't know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have.
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
Sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you, then so.
Honestly, that sounds like a fair deal to me. If this guy wants to completely ruin his own life, then hey, go right ahead. But if he has even a shred, just a shred, of common sense left, he should be sprinting to find a lawyer and staying completely silent until then. After that speech from the judge, I mean, come on. Even if I were as clueless as this guy, I'd realize that getting legal representation might be the smartest move I could make. But let's be real, we all know what he's going to do next. He's going to keep running his mouth and digging himself into a deeper hole, just like every other sovereign citizen. Because honestly, these folks don't seem to care about consequences. In their heads, they're not just above the law, they think they're above the court, and maybe even above reality itself. Whether it's politics, conspiracy rabbit holes, or something else entirely, this mindset is getting more extreme by the day. And yeah, it's concerning. At this rate, I wouldn't even be surprised if one of them tried to pay for groceries with monopoly money. Who knows? Maybe that's already happened. Let me know in the comments if you think there's any hope for guys like this, or if we're just watching the circus unfold in real time.
I got a question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right.
Judge,
I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. Do you, I got a question. Should they have sent me something before they send me this package since the last court date
Sir,
to verify that?
sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case. The same way
Okay,
they can't
so
tell you.
she's gonna send me a packet and I'm gonna send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said the
Don't
discovery
interrupt me again.
for me
We had
and
this
her.
conversation before, didn't we?
Sorry,
We
Go
had
ahead.
this conversation before.
go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written request for discovery, you have a right to do that too. You can send written interrogatories, request for production of documents, and request for admissions. Same as her.
All right, everyone, so get this. He actually accepted the packet. I know I just called him an idiot, but maybe, just maybe, his last two brain cells finally fired up and made a decent decision. Now, he's back for his next court appearance, and you've got to hear what he says. It's beyond ridiculous. The judge literally laughs in his face, and honestly, you'll probably do the same. With all that said, let's jump into the next part and see how this circus continues to unfold.
All right, we are on the record. This is 21-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
Is there anything else you want to say, Mr. Hurst?
That's it.
All right. All right, where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay, let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
Yeah, I'm asking
Okay, yeah.
if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay, so let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay, July 26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan court rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the counsel for the others.
All right, everyone, here it is. The moment we've all been waiting for. This guy finally submitted his motion, and let me tell you, it's pure comedy gold. I'll let you be the judge, but personally, I've watched this part more than a few times, and it never stops being hilarious. And the judge's reaction? Absolutely priceless.
All right, the court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate, with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and/or have proof that the statute of limitations has not expired to collect on his alleged debt. Plaintiff admitted that. Does the plaintiff admit in number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? Plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is we have an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have in our request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to the court rule, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must by affidavit or as otherwise provided in this rule demonstrate the existence of genuine issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the 3rd page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7-day rule, I'd appreciate it.
What a way to end this circus. This guy actually filed a motion that basically admitted guilt and then didn't even bother to show up. That's the legal equivalent of saying, yeah, I did it, and then ghosting the court. Honestly, it's almost impressive how badly thought out his plan was. It's obvious he was just plain dumb, probably hoping the judge would magically erase the debt he owes the credit firm. Spoiler alert, that's not how it works. Once a judgment is entered, the creditor can go after your wages, freeze your bank accounts, or even place a lion on your property. But hey, who needs real legal advice when you've got YouTube conspiracy videos, right? Jokes aside, sovereign citizens are becoming more than just an internet sideshow. They're a real problem. Sure, we love watching the courtroom clips for entertainment, but the truth is, these people waste valuable court time, flood the system with nonsense filings, and hold everything up with imaginary loopholes while real cases get delayed. Imagine being a legitimate defendant with an actual issue, only to be stuck behind someone ranting about being a free inhabitant with no legal obligations. It's ridiculous, and unfortunately, this behavior isn't just limited to the courtroom. Some of these people refuse to pay taxes, drive without licenses, or even squat in other people's homes because they believe laws don't apply to them. This goes way beyond delusion. It's dangerous. Personally, I think courts need to start handing down harsher consequences for this kind of behavior. Whether it's political or just the result of falling down conspiracy rabbit holes, something needs to change. Let me know what you think in the comments. Was the judge's reaction your favorite part? And do you think the sovereign citizen movement is just harmless noise or something more serious? If you enjoyed this breakdown, make sure to hit that like button and subscribe for more content like this. I really appreciate you watching. Take care, and I'll see you in the next one.